Okay, we'll continue our discussion. Taxation, Chapter 2. Now we're on sources of tax laws. The different sources of tax laws are statutes, which are also known as legislations or laws. And we have presidential decrees. These are enacted by the president. Executive orders, also be given out by the executive branch, who is the president, and the Constitution. We have court decisions, also known as jurisprudence, tax codes, which are namely the train law, the VAT reform law, the expanded EVAT, and the NIRC, or the National Internal Revenue Code. Then revenue regulations. These are circular orders or administrative issuance, also from the BIR, likewise rulings from the BIR and local tax ordinances of the LGUs. And we have tax treaties and conventions with foreign countries. Now there are requisites to follow in order that the tax regulations or tax law will be valid. Number one, firstly, it must be reasonable, that it must be within the authority conferred, that should be contrary to law, and it must be published. For a law, if not published, it will not be valid. For the taxation, for publication requirement, not all sources of tax laws require publication in the official gazette, as provided in Article 2 of the Civil Code. Now, the official gazette is the official newspaper of the Republic of the Philippines. In this case of Tañada versus Tavera, it was decided in 1986. It states that the court says that the following need publication as a condition for their effectivity: statutes, including those of local application of private laws, presidential decrees and executive orders promulgated by the president, and administrative rules and regulations, if their purpose is to enforce or implement existing law pursuant to a valid delegation. So only up to here, revenue regulations and administrative issuance. So BI rulings need not be published. But local tax ordinances must be published. Okay, let's go to interpretation or construction of tax laws. Interpretation is also termed as construction, so they're synonymous. So how do you interpret or construct tax laws? So firstly, statutes levying taxes are construed against the government. So tax laws must be clearly, expressly, and ambiguously stated that it is levying taxes or duties. Because in case of doubt, the law is strongly construed against the government. So number two, or second, construction of statute by predecessors is not binding on the successors. So the predecessors and successors referred here are the Secretary of Finance. So the power to pass upon the validity of general circulars vested exclusively in our courts in view of the principle of separation of powers. So meaning that the one vested with exclusive authority to interpret laws is only the courts. However, the Secretary of Finance is also authorized to give out general circulars for interpretations on tax statutes. But his interpretation can also be revoked, repealed, or abrogated by the acts of his successor. See? So, let's say the old Secretary of Finance stated that 1 plus 1 equals 3. So this can be revoked or repealed by the new Secretary of Finance. And it can, she can correct that 1 plus 1 is equals 2. So whatever rulings that the predecessor has or interpretation of laws that he has been administering is not binding on the new Secretary of Finance or the successor. If thereafter the successor becomes satisfied that a different construction should be given. So if the new Secretary of Finance think that the rulings given by the former Secretary of Finance is erroneous, or there should be a new construction, or it should be interpreted differently, then the old Secretary's interpretation can be revoked. Okay. Thirdly, retroactive application. So this already discussed that tax laws should only be applied prospectively, except if they are clearly intended to be retroactive in application. So there are exceptions to the non-retroactivity of rulings. And so revocation, modification, or reversal of any rules and regulations promulgated by the Secretary of Finance or the CIR, who's the Commissioner of Internal Revenue, shall not have retroactive effect if it will be prejudicial to the taxpayer. So whatever rulings or revocation the Secretary of Finance has made or the CIR, it's not retroactive, except where the taxpayer deliberately misstates or omits material facts from his return or in any document required of him by the BIR. So there's a clear or intentional misstatement or omission of material facts. Second, where the facts subsequently gathered by the BIR or the Bureau of Internal Revenue are materially different from the facts on which the ruling is based. So it's very different. And then where the taxpayer acted in bad faith. So these are the exceptions to the non-retroactivity of rulings. Fourth, special laws prevail over general laws. So tax laws are special laws. So tax, while the civil code, which is the obligations and contracts, is a general law. So tax laws prevail over general law. So the demand on the taxpayer to pay is an assessment for deficiency franchise tax. As such, the right to assess and collect the same is governed by Section 331 of the Tax Code, rather than Article 1145 in relation to Articles 1154 and 55 of the Civil Code, which provide for prescription up to 6 years. So this case, Guaga Electric Light Plant Company versus Commissioner, the defense that they're not paying the tax is because it has already prescribed according to the Civil Code. But the Supreme Court said that what should apply is not the Civil Code, because tax law is a special law. So there are prescriptions which are stated also in the tax code itself. So again, prescription is expiration. Okay, now let's go to tax administration. So what is tax administration? It's defined as a system of collecting taxes in accordance with the country's uh, tax policies. It involves enforcement of taxes through the following aspects of taxation. So these are the aspects of taxation. Number one, levying or imposition. This is the legitimate act which the legislative body enact tax laws, including tax exemptions. So in the process, Congress determines the nature of tax, the subjects to be taxed, the objective or purpose of the tax, the rate, and the tax base, and how taxes are imposed and collected. The levy is, as a remedial measure, is the power of the BIR to attach real properties for taxpayers who does not want to pay tax. So levying includes attachment of the property of taxpayers if they do not pay. The second aspect of taxation is assessment. This is the act of administration and implementation of tax laws by the executive branch through its agencies, the BIR and BOC. So BIR is the Bureau of Internal Revenue and BOC is the Bureau of Customs. So generally, taxes are self-assessing, meaning taxpayers can compute it in himself. So that's the first kind of assessment, self-assessment. So the taxpayer computes the tax by himself. But to define assessment, it is the appraisal and valuation of the subject of taxation. It is important in determining tax prescription, surcharges, and interests to arrive at the sum of tax charged on a person, a property, or right. So these are the subjects of taxation: person, property, or right. The third aspect of taxation is collection, which is essentially administrative in nature and includes criminal prosecution for forfeiture of property and among other else. So the agencies in charge of tax administrations is the Department of Finance. So principally responsible for the fiscal policies and general management of Philippine government's financial resource. Pardon for the wrong spelling. It has supervision and control over the following: the BIR and the BOC, the Land Transportation Office, the duly authorized collectors, local offices in charge of local taxation, such as provincial cities. Okay. Now, the agencies of the Department of Finance are these two. No, the Bureau of Internal BIR, primarily in charge to assess and collect all taxes and charges imposed by the train law, the NIRC, and other tax laws and regulations. The Bureau of Customs and the Tariff Commission are tasked to enforce the Tariff and Customs Code. The BOC also collects taxes on imports embodied in the train law. Now, the LTO, who is under the Department of Transportation, is responsible to collect registration fees and motor vehicle tax. So there's a tax aspect on the collection of LTO. Fourth, duly and lawfully authorized collectors. So these are persons, agencies, or duly accredited banks authorized by the BIR, BOC, TC, and LTO to collect taxes. So these are land banks, the DVP, and and other banks. Fifth, local offices in charge to enforce local taxation, such as provincial, cities, municipalities, and barangay treasurers. Province and city assessors, Board of Assessment Appeals, and Central Board of Assessment Appeals. So let's go to the BIR, organizational structure. Now the BIR is headed by a CIR, or Commissioner of Internal Revenue, and 6 deputy commissioners. So other BIR officers are, let's go to the deputy commissioners. The deputy commissioners, since there are 6 of them, each one heads this different committee or group: the operations group, legal enforcement, information systems group, the resource management, tax reform administration group, and special concerns group. For revenue regional directors, there are okay. So in every region, there are revenue regional director assigned. And then for every office, there are revenue district. It is headed by a revenue district officer. So here in Cebu, we have 1, 2, 3, 4, 5. There are 5 revenue district offices. And so there are also 5 revenue district officer. Okay. Actually, there are only 4, because Lapu-Lapu City is under Mandawi City. So 1 in Mandawi City, 2 in Cebu City, Cebu City North and Cebu City South, and 1 in Talisay City. So Mandawi City is in charge for North cities and municipalities like Bugo City, Danao City, municipalities of Carmen, Tabugon, what else? Liluan, Consolacion. So those in the north. And also Lapu-Lapu City, that's Mandawi City. So in the city of Cebu, there are 2 RDO, or revenue district officers. So 1 is the head of revenue district 081, which is the north. The north is, so Cebu City is divided into north and south. So the boundary line is the Osmeña Boulevard, no? From Capitol down straight, you follow Osmeña Boulevard all the way to Plaza Independencia. So the one on the, if you are facing Capitol, so the one on the right is the north, this area, or revenue district office 081. And the one, if you're facing Capitol, the one on the left is the south, which is revenue district office 082. Okay, so if you're facing Capitol and you are standing on the center of Fuente Osmeña, the one on your right is the north. So Park Place Hotel, so on your right is situated on the north, Cebu City North. Also Robinson's Mall or Midpoint Hotel is also north, no? So while on the left side, which is the Chonghua Hospital. It belongs to Cebu City South District. South Chonghua Hospital, uh, Robinson's. What is that? Robinson's near Chonghua or in front of Chonghua. Cybergate. No, Robinson's Cybergate is. It belongs to the Revenue District Office of Cebu City South. So the Revenue District Office number is 082. Okay. So all these Revenue District Office has revenue examiners and officers. Then there are division chiefs and BIR collection agents. So BIR officials are charged with assessment and collection of all national internal revenue, taxes, fees, and charges, including penalties and fines for violations of certain provisions of train law and special laws administered by the Commissioner. So the following officials are constituted as agents of the CIR: the Commission of Customs and all his subordinates with respect to the collection of VAT and excise tax on imported goods, the head of appropriate government office and his subordinates with respect to collection of energy tax, and the authorized banks with respect to the receipts of payments of internal revenue taxes authorized to be made through banks. So a bank officer or employee involved in this task shall be subject to the same sanctions and penalties under section 269 and 270. So violations committed by government enforcement officers and unlawful divulgence of trade secrets. The 1997 tax code as amended by the train law. Okay. So what are the powers and duties of the BIR? First, to assess and collect national internal taxes, fees, and charges. To enforce all forfeitures, penalties, and fines connected therewith. Third, to execute judgment in all cases decided in its favor by the CTA or Court of Tax Appeals and the ordinary courts. So CTA is Court of Tax Appeals. Fourth, and lastly, to effect and administer the supervisory and police powers conferred upon it by the tax code or other special laws. For the Commissioner of Internal Revenue, his powers in order to effectively enforce tax laws and collect taxes are the following. Number one, he has the power to interpret tax laws and to decide tax cases. So his interpretation of the tax laws is subject to the review of the Secretary of Finance. So this exclusive jurisdiction given to the Commissioner of Internal Revenue to interpret tax laws has been provided for in Republic Act 8424, which is the NIRC. So this is in 1997, not 1998. So this is in order to avoid so many interpretations from different government agencies like the BIR, the DOF, the DOJ, the Board of Investments, and even in the Office of the Secretary, Executive Secretary, which are conflicting to one another. So the exclusive authority has been given to the CIR, Commissioner of Internal Revenue. The second power is to decide disputed assessments, refunds of taxes, fees or other charges, penalties, and other matters arising under the tax code. Of course, this is subject to the appellate jurisdiction of the Court of Tax Appeals. So if there are cases which are appealed to the CTA, it can be overruled or revised. And then CIR has also the power to examine books and other accounting records and obtain information in order to ascertain the correctness of any return, or in making a return when none has been made. So he can make you a tax return if you have not filed. So in determining the liability of any person, or in collecting any such liability, or in evaluating tax compliance. So his power includes the summoning persons. So he can order summons in order that this person will testify on tax matters of another taxpayer. His fourth power is to inquire into bank deposits of taxpayers, but only in these two instances. First, if a decedent dies, if a person dies, and in order to determine his gross estate, meaning his total property, this person is already dead, then the CIR can inquire into the bank, the deposits of the dead person in all banks. So this is not a violation of the bank secrecy law. Okay. Now this has been amended. Before it, the heirs of the dead person or the decedent. So when a person dies, it is termed as decedent. Deceased person, decedent. So if a bank has knowledge of that the depositor is already dead, and he maintains a bank account in the branch of the bank, even if it's joint, the other person or his heirs can withdraw the bank deposit. Before, they cannot withdraw. No, they have to pay state tax first before getting the clearance, in order that the bank deposit can be unfreezed. Now, the joint account holder or the heirs of the decedent can withdraw already the bank deposit, provided that a final withholding tax of 6% is deducted and transmitted to the BIR. So it is the duty of the bank to withhold 6% as final tax. No? Final withholding tax. Now, for this purpose, all withdrawal slips shall contain a statement to the effect that all of the joint depositors are still living at the time of withdrawal by any one of the joint depositors, and such statement shall be under oath by the said depositors. So there should be acknowledgement of a notary public. So now I notario. Okay. So the other case would be that the Commissioner of Internal Revenue can inquire into the taxpayer's bank account is when the taxpayer who has filed an application for compromise of his tax liability under Section 204A of the tax code. So he's entering into a compromise by reason of his financial incapacity to pay his tax liability. So in this case, the CIR will now inquire on his bank deposits to ascertain if it's telling the truth, no? Because he has made an application for compromise. So therefore he is waiving, he must waive. So it's required here that unless and until the taxpayer waives in writing his privilege under Public Act 1405, which is the bank secrecy law, and such waiver shall constitute the authority of the CIR to inquire into the bank deposits of the taxpayer. And we go to his fifth power. The CIR has the power to assess and collect the correct amount of tax. So examination of returns and determination of tax due. So after the return has been filed by the taxpayer, the commissioner or his duly authorized representative may authorize the examination of any taxpayer's return in order to assess the correct amount of tax. Notwithstanding any law requiring the prior authorization of any government agency or its instrumentality. So even though there is a law requiring prior authorization, no? But provided, however, that failure to file a return shall not prevent the commissioner from authorizing the examination of any taxpayer. So even if you have not filed your income tax return, the CIR can authorize somebody to examine the taxpayer. Sixth power, CIR has authority to compromise, abate, and refund or credit taxes. So compromise, meaning the taxpayer is these are the instances when the CIR has authority to compromise. Number one, when there is reasonable doubt as to the validity of the claim against the taxpayer exists. So there is a doubt that exists. So malabo ang pag-claim, no? So in this instance, the CIR can order, say, we will order into compromise. And then second, the tax or any portion thereof appears to be unjustly or excessively assessed. So the amount assessed is overstated or excessive. In that case, the CIR can order compromise. By the way, abate is reduce or reduce, and refund, reimburse, or credit taxes if the taxpayer would opt. Then third, the financial position of the taxpayer demonstrates a clear inability to pay the assessed tax. So no more money to pay. Or fourth, the administration and collection costs involved do not justify the amount to be collected. So let's say the amount to be collected is 10,000 pesos, and if you file in court, it would you would hire a lawyer, and hiring a lawyer would be costly nowadays, would amount to 200,000 pesos. So why go to court? Just settle, compromise. Okay, it's compromise. If you pay 10,000, instead of paying 10,000, you pay just 5,000. That's compromise. So the CIR also has the power to suspend business operations. For a VAT registered person, he can suspend it if the VAT registered person fails to issue receipts, invoices, or fails to file VAT return, or understate his taxable sale by 30% or more of his correct sale for the taxable quarter. So the VAT return should be filed every quarter. And then he can also suspend business operations if the taxpayer fails to register as required under provision or section 236 of the National Internal Revenue Code. So these are the means employed in the assessment of taxes: examination of tax returns, use of best evidence obtainable, inventory taking, surveillance, and use of presumptive gross sales receipts, termination of taxable period, prescription of real property values. So the CIR or the Department of Finance can provide real property values. The prescription here is not synonymous to expiration. This is a different prescription. This is the noun form of the verb prescribed. No? So prescription. So prescribe real property values here. Number 6, examination of bank deposits to determine the correct amount of gross estate of the decedent or the deceased person. Accreditation and registration of tax agents, and prescription of additional or prescribed additional procedural or documentary requirements. So in order to effectively and efficiently perform tax collection, so those who are engaged in business or employed in business must comply with the following. So if you are engaged in business, you must comply. If you are also employed, you are required to comply. First, you must register. So there should be registration. So it happens only once with the appropriate BIR office for assignment of tax identification number or TIN. So one person is assigned a permanent TIN. So in case you're issued 2 TINs and you obtain it fraudulently or by fraud, you would be criminally liable. Okay. So there can be 2 TINs or TIN in this cases, a division of a local or foreign bank in the Philippines, which is a foreign, there's wrong spelling here, which is a foreign currency deposit. So, or when a taxpayer dies, a new TIN or TIN shall be given to his estate. Like, say, for example, Juan de la Cruz died. So, his TIN would be different when the estate of Juan de la Cruz will pay the taxes, no? So estate of Juan de la Cruz will now have a different TIN. So these are the only instances whereby 2 TINs are issued to the same person. So one, if there is a local bank or foreign bank who has a foreign currency deposit. Yeah? So there's only one bank, but he has a foreign currency deposit. So the foreign currency deposit is given a different TIN. If it is a foreign bank in the Philippines, like for instance, Maybank, it is owned by a Malaysian, Malaysian bank. So Maybank has a different TIN if it has a foreign currency deposit branch or unit. So when a taxpayer dies, his estate is given a different TIN. So when do you register? So a person is required to register 10 days from date of employment. Now, if engaged in business, it must be, he must register on or before its commencement, or before payment of any tax, or upon filing of a return, or filing a statement or declaration. So in every year after registering, the business, we are only talking about business here, businesses must comply with the annual registration fee, which is 500 pesos per business and shall be payable on or before January 31. So if the business has 2 branches, so he must pay 2 annual registration fee. So he has 1 branch here in Cebu and 1 branch in Lapu-Lapu City. So that's 500 pesos per branch because it's here. 500 pesos per business per place. Okay. So who are not included here? Except those who are employed or employees. So annual registration fee is not a requirement. OFWs or overseas foreign workers or overseas contract workers and cooperatives. No, there is no annual registration fee. So registration forms for self-employed or mixed income individuals, estates and trusts. It's they are form 1901. So self-employed, you have your own business. Mixed income, you are employed and at the same time you are exercising your profession. Like me, for instance, I'm employed with the CITU as a professor, but I am also a practicing lawyer, a CPA, REB, real estate broker. So I belong to the mixed income individuals. For estates, those who are already dead and he has a business which is still operating or operational, and trusts. For employed individuals, so those who are earning pure compensation income, the form to use is BIR Form 1902. For corporations and partnerships, BIR Form 1903. For one-time taxpayer and other under EO Executive Order number 98, meaning given the opportunity to transact with government only one time, so BIR Form 1904. And if you want to update or cancel your registration or your TIN, or you want a new copy of registration, and that would be Form 1905. For annual registration fee, the BIR form to use is 605. So we're still under administrative provisions. Second is to comply with the printing of receipts, sales or commercial invoices, because the Department of Finance, in order to collect taxes, you must substantiate your sale with receipts. No? So businesses are required to print receipts, sales or commercial invoices. So what are sales or commercial invoices? It is a document issued by the seller of goods to the buyer, while receipt or official receipt is a document issued for sales or services. Okay. So, but in practice, sales invoice are those utang, no? Sales invoice, meaning it's still not yet paid. So there's a sale but not yet paid. Well, official receipt, it can be construed that the buyer has already paid the sale. So requirement number one, the taxpayer will ask from the BIR an authority to print. So authority to print must be accomplished in BIR Form 1906. So kailangan lang mo print og resibo. BIR Form 1906. So required, the receipts, in order to be valid, there must be serially numbered. So it's pre-numbered. The resibo contains the name, the business style, the TIN, and address of the taxpayer or the entity to use such receipts or invoices, and contain information required by other rules and regulations like senior citizens ID number, discounts of PWDs. And third, in order to, the administration of tax laws would be easily facilitated, taxpayers are required to issue receipts and sales or commercial invoices. So this is issued every business transaction for sales or services more than 25 pesos. So these receipts or sales commercial invoice, regardless of amount, if payment made as rentals, commissions, compensations, or fees, or the sale is made by a person liable to VAT or value-added tax, to another person also liable to pay VAT. No? So this answers the question, when should receipts be issued? So when the transaction involved is, or the amount involved is more than 25 pesos, you must issue a receipt. Or even if it's, regardless of the amount, if it's rental, commission, compensations, and so on and so forth. Original receipt is issued to the payer. Each person shall keep the respective copies in his business for a period of 3 years. Why 3 years? Because after 3 years, you can already discard official receipts. Then businesses are required to exhibit a certificate of payment at place of his business. So in the office or in the store, you're required to exhibit your certificate or receipts showing that you have paid taxes and you are engaged in business. And this is about the annual registration, because you'll be given receipt, no? If you will renew your registration. It should be kept in plain view at the place where the business is conducted. So in case of persons without fixed place of business, it shall be kept in the possession of the holder thereof. So if you don't have an office, you'll be bringing always your annual registration receipt or fee, and shall be presented upon demand of any BIR officer. Okay, so any BIR officer can demand, oh, where's your annual registration receipt? So if you notice, if you would enter into a store, there is a certificate that it has complied with the annual registration. It's sometimes laminated and framed in a picture frame. No? Okay. What are the tax remedies under the NIRC or the train law? There are 5: summary, substantive, procedural, administrative, and judicial. Summary, these are remedies at the administrative level. Here, administrative level. Executed without ceremony or delay. This is short or concise. Summary. Paspasa ini. Substantive, these are remedies provided for by law or regulation, an essential part or constituent or relating to what is essential. Procedural, these are remedies involving law, pleading, evidence, jurisdiction. So this is mostly in the court. Then we have administrative within the BIR level or the Department of Finance level. Judicial, the remedies are already enforced through judicial action or filing a case in court, which may be a civil court or a criminal court, or could be a civil case or criminal case. So how does the BIR collect taxes, or the BOC? So this is administrative level, again within the BIR or Department of Finance level. There's number 1, the restraint of personal property. If the taxpayer refuses to pay his tax liabilities, then his personal property can be restrained, subject to attachment. No? Restraint is seizure. Then levy of real property. This is different from the other levy. Levying and the other one is imposing or enacting laws. This levy of real property pertains to the seizure of real property. And other administrative collection remedies. In the judicial level, this is already filing a case in proper courts. Could be civil action or criminal action. So if the person has defrauded, committed fraudulent filing of his income tax, then he is criminally liable. Like tax evasion, criminal action. Okay. Then we have tax remedies, still under tax remedies. So let's go to assessment. So meaning of tax assessment, it is the official action of an officer authorized by law in ascertaining the amount of tax due under the law from a taxpayer. So it is the process. No, this action necessarily involves the computation of the sum due, giving a notice to that effect to the taxpayer, and making simultaneously with or sometime after the giving of notice of a demand upon him for the payment of the tax deficiency stated. Then there is tax audit. Audit is the process of examining, going over, or scrutinizing the books and records of the taxpayer to ascertain the correctness of the tax declared and paid by the taxpayer. It can only be performed upon a letter of authority issued by the commissioner or the regional director. So this happens to my client. There were tax examiners in his store. No? When he opened his store, the tax examiner presented the letter of authority issued by the commissioner of the Internal Revenue that they are going to conduct examination and scrutinizing the books of records of the taxpayer of my client as an audit. So the letter of authority, which is issued by the commissioner, is a commission which grants the revenue officer or the officer assigned to perform assessment functions the power to conduct an examination of the books and records of a taxpayer within its jurisdiction of the district in order to collect and correct the amount of tax or to recommend the assessment of any deficiency tax due. So there's another notice, which is the pre-assessment notice. So this is given to the taxpayer, informing him of the findings of the BIR officer relating to the deficiency in his tax return, indicating in the letter the law and the facts on which the assessment is made, and requiring him to respond within a given period, usually 15 days or 30 days. Otherwise, the CIR or his duly authorized representative shall issue an assessment based on his findings. So this is a requisite of due process of law. So after the examination, the taxpayer is given the pre-assessment notice. So this is based on our audit, we have uncovered like this and that. You have a deficiency tax of, let's say, 20 million pesos. Oh my gosh. So instances where pre-assessment notice is not required. Number one, when the finding for any deficiency tax is the result of mathematical error in the computation of the tax as appearing on the face of the return. So there is mathematical error in the computation. So there is no pre-assessment notice required. Or when the discrepancy in the tax has been determined between the tax withheld and the amount actually remitted by the withholding agent. So there's a discrepancy in the withholding tax. Number three, when a taxpayer who opted to claim a refund or tax credit of excess creditable withholding tax for a taxable period was determined to have carried over and automatically apply the same amount claimed against the estimated tax liabilities for the taxable quarters or quarters of the taxable year. So there is an over deducted tax, withholding tax. So that can be carried over on the following year as a tax credit. No? So in that case, there is no pre-assessment notice. Another case when the excise tax due on excisable articles has not been paid. So excise tax is not a ground for issuing pre-assessment notice. Also, when an article locally purchased or imported by an exempt person, so there are exempted persons like church, like NGOs, non-profit NGOs, but not limited to vehicles, capital equipment, machinery, and spare parts, has been sold, traded, or transferred to non-exempt persons. So in this case, no pre-assessment notice is issued. Then after the pre-assessment notice is issued, comes notice of assessment. So a notice given to the taxpayer by the BIR informing him of the amount of deficiency tax for which the taxpayer has been assessed based on the findings of the BIR upon failure of the taxpayer to respond to the pre-assessment notice or after an examination has been conducted. So after the pre-assessment notice is given and the taxpayer did not respond, so he's in default, therefore there is now notice of assessment. Then there is deficiency assessment. This is the amount by which the tax properly due exceeds the sum amount of the tax shown on the taxpayer's return. Meaning the income tax filed by the taxpayer is way below or too low compared to the tax, which is the due, which is properly computed by the examiners or the tax authorized examiners. So, dako ay ang bayaran niya yung gibayad gamay ra. So in this case, BIR will issue deficiency assessment. So you have a tax deficiency. Instead of paying 100,000, you only paid 30,000. So you are deficient of 70,000 pesos. So the amount a taxpayer is deficient is tax payments. Okay. Then we have delinquency tax assessments. This is the state of a person upon whom the personal obligation to pay the tax has been fixed by lawful assessment and thereafter fails to pay the tax within the time limited by law. So he's given, let's say he's given deficiency assessment. Well, sir, you have to pay this because you have a deficiency. So your tax payment is way below our tax assessment. So there's a deficiency assessment. Now he fails to pay. Because BIR said you have to pay this within 1 week time. He fails to pay. Taxpayer failed to pay, so therefore he becomes delinquent. No? So this time there is now issuance of a delinquent assessment. Another assessment is a jeopardy assessment. It is an assessment made demanding immediate payment of the tax due without the usual formalities in the instances when the commissioner believes that if the tax will be collected under normal procedures, the collection of such tax is at risk, which might result in loss to the government. So there is risk, meaning the government is jeopardized. So the assessment issued is jeopardy assessment. So instances when jeopardy assessment may be issued, number one, when it shall come to the knowledge of the commissioner that taxpayer is retiring from business subject to tax. So retire siya, intending to leave the Philippines or remove his property therefrom, or to hide or conceal his property, performing any act tending to obstruct the proceedings for the collection of tax for the past or current quarter or year, or to render the same totally or partly ineffective unless such proceedings are begun immediately. So there is risk that the government will lose the collection, no? Because of these instances. So the power of the commissioner to assess deficiency tax based on best evidence obtainable under Section 6B of the Public Act 8424 empowers the commissioner to assess the proper tax and make or amend the return based on best evidence obtainable. So from his own knowledge, from such information as he can obtain through testimony or otherwise. So when a report required by law as a basis for the assessment on any national internal revenue tax shall not be forthcoming within the time fixed by laws or rules and regulations, or there is reason to believe that any such report is false, should be one sentence, or incomplete or erroneous, and the return made by the commissioner in instance shall be prima facie correct and sufficient for all legal purposes. So what are the requisites for a valid assessment? Number one, there must be post-reporting notice or notice for an informal conference after the tax audit. So after a tax audit, there should be a NIC. Then comes pre-assessment notice if required. Then issuance of notice of assessment. So there must be issued prior to lapse of prescriptive period. The notice must state the facts that the law upon which the assessment is based. Assessment period, these are the time allowed by law for a BIR to investigate a taxpayer's tax deficiency, which are 3 years if there is simple neglect, and 10 years if there is willful neglect. Willful neglect is fraud or omission. And this is 10 years from discovery of the fraud or omission. These are the assessment period or prescriptive periods. So to summarize the assessment procedure, we have here a diagram. No? So this is embodied in section 228 of the NIRC. This is not revised by the train law. So this is still enforceable. So first, BIR sends written NIC or notice of informal conference to the taxpayer. The taxpayer responds within 15 days from receipt of NIC. And if he fails to respond, so taxpayer is declared in default. And the BIR, after 15 days, will issue the PAN or the pre-assessment notice. So once receipt of the PAN or the pre-assessment notice, the taxpayer is required to respond within 15 days. See, from receipt of the PAN. It's right here. If he fails to respond, then the taxpayer is in default. Meaning, he can no longer, his time to respond is already expired. Then BIR, after 15 days, will issue formal letter of assessment. So once taxpayer receives formal letter of assessment, he files protest within 30 days from receipt of the assessment. So there is still a remedy for taxpayer to file protest. And he must submit proofs which would counter the claim of the assessment within 60 days from filing of the protest. So this is a time frame, no? 30 days to file protest, then he has 60 days to submit proofs. If there is no supporting document submitted, then the assessment becomes final. So if he submits proofs, then the BIR will again serve another notice, and this is to denying taxpayers' protest, or if it ignores supporting documents within 180 days, It is 6 months upon submission by the taxpayer. If he ignores, then the remedy of the taxpayer is to appeal the case to the CTA or the Court of Tax Appeals within a period of 30 days from receipt of the denial or from the lapse of the 180-day period. So after 180 days, you have to count 30 days in order to file your appeal with the CTA. So you count 180 days if the BIR does not respond or ignores your supporting evidence, okay? But if the BIR will flatly deny your protest because according to them, according to the BIR, your proof is without basis. So you have to count only 30 days before your right to file an appeal would elapse, okay? So if there is no appeal made by the taxpayer, the decision on the tax assessment becomes final, executory, and demandable. So whatever the BIR has assessed the taxpayer, let's say you are in the letter, the assessment letter of assessment, it says that taxpayer must pay 3 million pesos as deficiency tax, then taxpayer will become liable to pay because it has the assessment becomes final, executory, and demandable. So this is the summary of all the discussions that we made. Not all, but some. No? So additions are add-on to tax liability. So let's say the BIR has stated that you have deficiency tax of 1 million pesos. Okay, bayranan, 1 million. There are additions. There are add-ons. Sa mga additions. Surcharges. Now, surcharges for simple neglect is 25% on the tax assessed. So plus 25%. But imposed on the following: fails to file any return and pay the tax due thereon. Files income tax returns with the wrong BIR office, other than with whom the return is required to be filed. Instead of filing with the Cebu City North, you filed in Cebu City South. That's wrong venue, wrong BIR office. No? You shall be liable for surcharge. Failure to pay the deficiency tax within the time prescribed for its payment in the notice. Additional 25%. Then, in case of willful neglect, katong fraud or omission, then the surcharge is 50% of the tax or deficiency. Willful neglect, willfully neglects to file a return within the period prescribed by the tax code or by rules and regulations, or by present false, or the taxpayer presents false or fraudulent return to the BIR, which are intentional. These are the false, the fraudulent return. Intentional under declaration of income. So imong income in this 100 million, you only stated 50 million pesos. Then intentional over declaration of expense. Instead, imong salary expense is only 10 million pesos, you bloat, no? You make it 20 million pesos. Intentional under declaration of selling price. Instead of, let's say you sold your house for 20 million, you only stated it's 10 million. So intentional under declaration of selling price. Or intentional overvaluation of cost of the property sold. You say you sold your property for 20 million, but you acquired it for 14 million. So you only pay income of 6 million. But in actual reality, you acquired the house or the property for only 5 million pesos, not 14. No? or recurrence of false return for more than one taxable year. So not only one taxable year, in the next year, again, the taxpayer filed a fraudulent return. So these are the instances when fraud is committed. No? Then another add-on or additions to tax liability is interest on deficiency tax. So the interest on deficiency tax is 12%. According to the court, that since tax are the lifeblood of the government, and their prompt and certain ability is an important need, because without revenue being raised from taxation, no government will survive. I think this is the wrong one. But interest on deficiency tax is 12%. 12% of the tax per annum. This is per annum. Okay. From the time the tax assessment, the tax liability should be paid up to the time they are actually paid. So the thing on BAR, oh, you must pay this one. When are you going to pay this? Tomorrow, November 4. But you did not pay on November 4. You only paid on December 4. So you'll be bound to pay additional 12% times 1 month divided by 12. Because per annum. Then in case of fraud, there is penalty. And how much is the penalty? It runs from 500,000 pesos, but not more than 10 million pesos. This is amended under the train law. Takbo na kayo ang penalty. 500 to 10 million pesos. Maximum is 10 million. So there are other collection remedies. First, imposition of injunction by the tax court. So injunction can only be made by a tax court because generally injunction is not available. So injunction is a restraining order for the court, for the government to stop the assessment, or stop the collection. So these are other collection remedies, but general rule, no injunction is allowed, only allowed if it is issued by a tax court. The number 2, tax lien. This is a charge or legal claim by the government to seize property, then sells the same. So all sales proceeds shall belong to the government and none to the taxpayer, because the seizure is a confiscation of property. Okay, so that's tax lien. So forfeiture, same as confiscation of taxpayers' property for the offense committed. So if property is injurious to the public, the same shall be destroyed. So this is in police power. Forfeiture. Let's say, for instance, you have a poultry full of chickens, but your chickens contracted the disease, H1N1, or the bird flu. So all of them shall be destroyed. That is confiscation or forfeiture of property. The 4th other collection remedy is forfeiture of government for want of bidder. In this case, there's no bidder, or there's a bidder, but it's way too low to pay the tax liability. So the property is forfeited, meaning the property of the taxpayer, delinquent taxpayer, is forfeited to the government as a satisfaction for the unpaid tax. So here the taxpayer has 1 year to redeem the property by paying the tax liability plus interest, expenses, etc. So he has the chance to redeem, meaning to get his property back. 5th, compromise. This is entering into a contract to avoid litigation, to avoid case, in other words, or put an end if already commenced. So if the case is already commenced, meaning to put an end to the case. So compromise is available in any stage of litigation, except now for criminal offenses or fraud, this can be compromised only before the case is filed in court. So what are the criminal offenses? Ito, omission, non-declaration, those fraudulent, no, willful neglect. Then 6, requiring proof of filing income tax return during renewal of business license or permit. So this is now the City Hall's responsibility to ask for proof of filing of income tax return. If the business is renewing his business license, so people in the City Hall will ask, hey, have you paid your income tax? Tanawa mo yung income tax return, sir. So those are other collection remedies. Then number 7, we have informer's reward. What is this? When somebody gives information which leads to the discovery of fraud, thereby resulting to revenue recoveries. So the informer is given a reward, which is 10% of the amount recovered, of course, less withholding tax. For smuggled goods, the reward is 10% or 10 million, oh no, 1 million per case, whichever is lower. So let's say smuggled goods would amount to 5 million pesos recovery. So the reward would be 10% of 5 million. That would be 500,000 pesos. Number 8, making arrest, search, and seizure for violations committed within the view of an officer. So this is in the plain view of an officer. So the BIR can arrest. Then deportation in case of aliens, additional penalty, those who knowingly commit fraud or evades paying taxes. So aside from fines, he shall be deported to his home country. Then 10, inspection of books. So what are the ways to contest the validity of the assessment? So whether on questions of facts or question of law. So the questions of facts are the events. The questions of law about the provision of the law. So these are the taxpayers' remedy or remedies. So firstly, file a motion for reconsideration. This is to request BIR to review the existing records without the need of new evidence. Then, or another would be motion for reinvestigation. This is to request the BIR for a second look based on newly discovered or additional evidence. Then there's another motion that is for withdrawal. This is to request the BIR or the court to remove the tax plea bargain he entered because of pressure to accept the agreement which is not in his best interest. And fourth, a motion for cancellation. This is to request BIR or the court to stop the tax assessment due to prescription and violation of due process of law. So due to prescription meaning there is already lapse of time, no? So the prescription was stated in the slides before. If it's in simple neglect, it's only 3 years. In willful neglect, it's 10 years from date of discovery of the fraud or omission. So there is prescription. So let's say there is simple neglect. So the BIR filed a case after 5 years. So there's no more case. Why? Because the case was already prescribed. Okay, motion for cancellation. So other remedies of the taxpayer. Number 1, ask for refund of internal revenue taxes which are illegally or erroneously collected or paid. Dispute and protest assessment by way of a consideration or reinvestigation within 30 days, and if denied, to appeal the decision within 30 days to the Court of Appeals. Here, reconsideration or reinvestigation. consideration or reinvestigation. Number 3, to contest for feature or of chattel. Chattel is another term for personal property. So if your motor vehicle is forfeited or seized by the BIR, so you have the right to contest for feature of your motor vehicle, which is a chattel or chattel. Number 4, to question the validity of the sale of real property for tax delinquency. So if your real property has been seized and sold in public bidding, so you have the right to question its validity. Then you have the right, the taxpayer has the right to redeem the property sold. So it is available in the forfeiture for want of bidding, or there is no bidding. Then person or the taxpayer can redeem, usually after 1 year period. Then number 6, to bring action against any revenue officer, meaning to sue internal revenue officers for damages caused in the performance of their duties. So you can file a case against these officers. So additionally, taxpayer can also avail of compromise or protest within 2 years from paying with the revenue collector. So protest from paying. So after, let's say for instance, you paid your tax deficiency based on the letter of assessment, you still have 2 years to protest. And where to file? With the revenue collector. And you can also avail of compromise. And where do you apply for compromise? With the revenue collector. So these are additional remedies. Compromise, that's one. Then protest within 2 years from paying, that's another. That's another remedy. Okay, that ends our discussion for chapter 2 of the Taxation 231. Again, you can utilize the book of Valencia or the book of Rex Bangawan. For questions or clarifications, you can email me at my Gmail account, Maceren and Maceren Law, or my FB account, Attorney Lyndon Mac. This is your host, your speaker, and your professor saying, have a good day.